Hey everybody, sorry I'm a minute or two late signing on. This is the Divorce Like a Pro series, the do's and don'ts of custody and your custody case. So I'm so glad that you've joined us here tonight. I'm going to let people sort of log in and sign in and join on before I officially dive into all the information we want to share with you tonight. So again, this is the Divorce Like a Pro series. It is part of the free Facebook Live series that Whitson Law Firm and Mediated Online Solutions host on a once-a-month basis, more or less, on all things family law related. And so tonight we're going to tackle the issue of custody. It doesn't have to be custody in the context of a divorce case. It could be for people who have never been married and share children or a child in common, and they're separating or breaking up and have to address the issue of child custody. So with that, I'm going to go ahead and officially get started in just a moment. But while we're waiting for people to hop on and join us tonight, I know some of you, maybe all of you, want to remain anonymous during this, but if you care to drop in the messages below, a little note about where you're tuning in from. So a city, a state, a country, whatever you care to share. It's fun for us to see where our audience is coming from, and we're happy to try to help you from wherever you are. So anyway, I'm going to go ahead and get started. So for those of you who don't already know me, I'm Debra Whitson. I am an attorney. I do family law, collaborative family law. I'm a mediator. I am a high conflict trained mediator. I'm trained in parenting plan mediation. And I'm also the author of Divorce Like a Pro, A Better Way to Break Up. You can find that on Amazon, Divorce Like a Pro, or put my name in. Or at the end of this, we'll put a link in the messages where you can download a digital version of that book for free from our websites. So thank you for joining us tonight. I'm so glad that you've tuned in. We're looking forward to giving you lots of information and lots of value as we go through this program tonight. So this is entitled The Do's and Don'ts of Your Custody Case. So I'm going to start by sharing my top 5 do's and my top 5 don'ts related to custody. Now, before I dive into the valuable information, a couple of disclaimers, because after all, lawyers love disclaimers, right? So disclaimer number 1 is I am licensed to practice law in the state of New York, and I have only practiced law in the state of New York, and I've been at it for almost 30 years. So I like to consider myself a bit of an expert in these topics, but if you are not in the state of New York, or you are in a different country, and we sometimes have viewers from Canada and other places, please understand that anything that I talk about concerning the laws surrounding custody and how procedures are handled surrounding court matters and custody cases, I am talking about my experience in New York. Okay, so be sure to check if you're in another jurisdiction whether the basic information or the general information I'm going to be providing you today that's New York specific applies in your situation. So that dovetails into my next disclaimer, which is there is no legal advice to anyone being dispensed in this program tonight or in any of our Facebook Live free programmings. That is because in order to give you individualized legal advice, first of all, you need to be in my jurisdiction, and I don't know where y'all are from at this moment. And secondly, I need to know your situation. I need to know the facts, I need to know the history, I need to know the players, etc., etc. And obviously, without that specific information, I can't give you targeted, focused legal advice. So there's no legal advice for your situation coming at you tonight, but hopefully a lot of good information that's going to give you the knowledge and the skills and the know-how as you're approaching your custody case, and how to navigate through your custody case and avoid some of the biggest pitfalls and set yourself up by doing the things that I think are wise to do to put yourself in the best position for the best possible outcome for your children and for you and your custody case. So I'm going to go ahead and dive right in. And because I like to start with the positive, I'm going to start with the things that I think are my top recommended to-dos for you. So things that you can do to help position yourself for the best, smoothest, and most child-centric custody case that you can imagine. All right? So do number 1. Put your children's needs ahead of your own. And I know it's easy to say that, and you're probably thinking like, well, duh, Deborah, of course I put my children first. But you would be surprised that when you're going through something like a custody case, especially if it's in court, and you've never been there before, or maybe you have and you just know that it's stressful and it's unpleasant and it never gets easier, going back more and more, that it's easy to fall into self-protection and self-preservation when you're under stress. So I want you to try to put yourself in your children's shoes as you're thinking about and deciding the things that you must decide to address custody and parenting related issues after a separation or a divorce. So what do I mean when I say walk in their shoes? So imagine being told, if you didn't have a clue that there was court in the house, that your parents are separating. Imagine the emotional shock and disappointment and sadness and grief that your children are experiencing. Imagine being the one who has to live your life for X number of years until you are out of your parents' household or households, going back and forth between 2 separate residences with a backpack, or having duplicate items in both places, and trying to remember where your favorite book is, or if you brought your soccer shoes with you before a soccer practice day. So most adults haven't been in that situation unless they were the child of separated or divorced parents. So if this is new to you, imagine how new and scary and disorienting and frightening it is for your kids. So try to walk in their shoes, try to put yourself in their psyche, and be sensitive to their needs and put their needs ahead of your own. This is the time to really be the bigger person. You may not want to share your children for a moment. Like, none of us want to think of having our children less than we had them when we had them in our household 100% of the time. But the reality is you can't have them 100% of the time, and there's got to be some give across both parents' playbooks on how to address the situation. So that's my number 1 do. If you wouldn't want it done to you, if you were a child in that situation, then don't do it to your child in this separation or divorce that you're embarking on. Okay. Number 2, let me just back up for a second and say everything I say tonight assumes that you're in a situation that does not involve domestic violence. And why do I say that here? Because domestic violence, depending on the pervasiveness, the severity, and so on and so forth, and whether the children have witnessed it or are directly targeted in the domestic violence household, is going to change and trump everything. So what I'm telling you tonight is like the usual discord that leads to couples breaking up and the decision that you're better apart than together. But if you have a situation where you or your children have been or will be in danger because of a separation and moving out into separate households, is a completely different situation. So you need to get, I recommend that you get advice from your nearest domestic violence advocacy and support center. Consult an attorney individually about your situation, particularly one who has some training and experience and understanding of the dynamics of domestic violence. Okay? All right. So again, assuming you are not in that situation, I want to encourage you to plan ahead if possible before you embark on a physical separation that's going to impact the kids, because it's best for them, it's best for you, and if you end up in court over these situations, it's going to present best in court if you took the time to plan ahead and to be prepared to manage the physical transition of the children from one house with 2 parents to 2 houses with separated parents and maybe others in the two houses handle the emotional transition and adjustment of, accepting and adapting to the fact that they no longer live in a single household with intact parents who are remaining a couple and raising them together. Also, prepare the children as you plan ahead so that they are ready for the changes. So you're going to want to have a conversation in advance of, we're moving out in an hour. If you can do that, right? You want to have a conversation, get them ready, have some time for them to adjust to the idea of what's coming ahead, and thinking ahead about how this will impact them and how to best support them through the adjustment of this huge life transition for them. I'm going to strongly urge you, as part of planning ahead, to engage counseling, get good counseling advice before you talk to the children and tell them about your separation or divorce, so you can help manage their psychological and emotional responses to learning about that. And consider lining up counseling for the children as they're going through this transition. Counseling is not a sign of weakness. It's not a sign that anyone is mentally ill or just not able to cope. This is a very big life change, and the more supports you have as you go through this very big life change, and the more supports you line up to help support the children and help you support the children through this change, the better off everybody will be in the final outcomes. All right, number 3. Do minimize the number of changes in the child's environment as you're making this transition from one household to more than one household. And what I mean by that is, if it can be avoided, try to keep the other constants in their life constant for them, at least for a while. So if you can avoid a change in daycare providers, if you can avoid changing their school during this transition, if you can avoid introducing new romantic partners or new household members, or blending families and introducing them to living with stepchildren right away, that will give them the time to adjust to the two household living situation before they are adjusting to other big changes in their environment. And even as adults, this is my advice to you as well. If you're going through a separation or divorce, try not to change a job. Try not to move to another city or state. Try not to start a school program or do something, a career change, something like that, all at once. It's a lot. Any one of those things is a lot. So try to focus on the huge transition from being a couple in one household raising children to you and your children living in two households, and you're sharing custody and parenting time with the other parent. All right, I think it's important for you to know in advance what's involved in court, what are some of the key terms you need to know and understand that the court will be addressing, and then have an idea of how the court would decide custody if they're required to. So at this juncture, I want to say that court is not your only option, and I'm going to argue to you and suggest to you that court is probably your worst option. And why do I say that? Well, there's a lot of reasons, but court is adversarial by nature. Every court case has a person A versus person B. So the versus means you are adverse to each other. You are adversaries by definition in that setting. Doesn't mean you have to go for the jugular and wage war against the other party, but the system is kind of built around that adversarial situation, and it tends to promote that just because it was built that way. So you have other options. You can figure this out on your own, sit down as level-headed parents and say, all right, we're not good together, but we're both decent parents. We're both reasonably flawed parents, because all of us are, and let's figure out what works best for the kids and our new living situation, and how to work all these things with everyone's schedules and such. That happens. It's not impossible. It is not necessarily the predominant way that these things get addressed, but many, many people can successfully do that. And then it's smart, if you can, to memorialize that in a written agreement, and maybe even submit that agreement to a court to have it approved as a court custody order. If you can't do that on your own, you could access mediation or hire collaborative lawyers to help you do that. Mediators and collaborative lawyers will help you stay out of court, stay in control of your final outcomes, make the process safe and civil and respectful for each of you, and help you overcome communication issues that are maybe stopping you on your own without assistance from reaching agreements or understanding each other or hearing each other. So, those old patterns of communication that led to your breakup might be getting in the way of you figuring these things out. So sometimes a little professional help from a mediator or a collaborative attorney can get you to a point where you can resolve these issues without court intervention. But if court is the only way for you to go because those other options aren't workable, your partner won't engage in those other options, or you've tried those other options and they just didn't work for your situation, then what I would suggest to you is that if you end up in court, you get a lawyer who is a problem solver and will help you try to structure settlement discussions and negotiations so there is still a very likely outcome that before you let a judge preside over a trial concerning your children and making a decision about your children for you, that you have an attorney working with the other side across the aisle, trying to negotiate a settlement short of trial. In the court setting, there's a couple of terms you should understand, and so I want to introduce those to you. One is the concept of legal custody. So legal custody is that element of custody that involves the parent's right and obligation to participate in raising their own child. So this is stuff like medical decision making for a child who's not able to make medical decisions on their own because of age or other infirmities that they can't make those decisions for themselves. Educational decisions for your children. Religion. Do your children get elective procedures or things done to their body, like piercings and tattoos before they're age 18 and can consent to that kind of stuff on their own? So all of those things fall under the umbrella of legal custody. So it is presumed, and it's in fact far more common, that people will share joint legal custody, and that means that they're obligated to participate, confer, discuss, share information, and come to a mutually agreeable decision about education, health, welfare, religion, upbringing, diet, etc. So if you are unable to do that, unable because you don't see eye to eye, if you say, I want my child to go to religious education, and the other says, I absolutely do not, and the child must be in public school, there's no perhaps meeting in the middle ground on that. So if you're just polar opposites on all sorts of major topics, one of you believes in Western medicine and the other believes in naturopathic or Eastern medications or medicine modalities, you're maybe not able to make mutual decisions. If one parent is unavailable because they're incarcerated, or they just refuse to communicate with the other, or they've disappeared, then one parent would have to necessarily have sole legal custody. So the court has basically two obvious options: joint legal custody or sole legal custody to one parent. The other side of the custody coin is, where do the kids spend their time? So this used to be referred to as physical custody. And if you go back a decade or more ago, somebody had physical custody and the other parent had visitation. We've moved away from that sort of construct and concept in more recent times because it's demeaning to say parents visit their children. Parents raise their children, right? So if you're in the custody game and you're raising your children, it's more common now to just say, how do we share parenting time? So parenting time can be shared equally. Parenting time can be shared completely unequally, but we refer to it as parenting time. And some parents need to have a schedule to be able to predict, to reduce conflict and points of decision making or possible disagreement with the other parent. So I've seen custody agreements and custody orders that spell out like every hour of every week and every special occasion and every holiday how the children's schedule will be handled and where the children will be and with whom. Other parents can say, we'll just work it out by mutual agreement and we will adjust and be cooperative, and their parenting time agreements or orders are much more fluid and flexible and short, brief. So, families are unique, and these things are not one size fits all. So the beauty with not having a judge decide these things is you can tailor these things to as many variables and considerations as you wish. So I have parents sometimes who have very unusual work schedules, and they go to great lengths to come up with a custody arrangement or parenting time arrangement that accommodates the children's schedules, the children's activities, and both parents' work schedules to an extent and with the kind of precision and thoughtfulness that perhaps a judge would not take the time to do, or really understand what it's like to be living all of those schedules and managing all of those schedules when the judge determines a parenting schedule. So how's the court deciding any of this if the parents can't decide on their own and reach agreement? Well, in New York, we have what's called best interest of the child, and I believe every other state in the United States has something like that. They may have a variant on that concept. And you're probably thinking, what does best interest of the child mean? And that's a great question. And it's not one I can easily answer because it's very fact specific. What's best for your child may be very different than what's best for my child. And what's best for one child in a family may be very different from what's best for the other children in that family. Because every child is unique and every family is unique. So in family court, there are laws that govern family court, but most of the outcomes of family court cases are driven by the facts of the unique situation as presented to the court by the attorneys for the parties in the course of the proceedings. Now, that's an important concept to understand because in presenting the facts of your case, there are rules of evidence, and some things come into evidence and other things are not allowed in evidence in courtrooms. And the court is never going to have the time or the patience or the resources to hear everything you would wish the judge to know about you as a parent, about the other parent, and about your children's needs and aptitudes and special habits and so on and so forth. So a family court's getting a really quick snapshot of what you and your children are like, and they're making a decision that can last for a really long time. So courts do the very best that they can do with the information available, but you know your child better than anyone, and in my opinion, it's best to avoid letting the judge get to the point where unlimited information, necessarily limited information because the time and evidence restrictions in courtrooms, that they're going to be hamstrung a bit because they're never going to know what you would really, really, really want to know in great detail about your children. All right, my fifth do is please do remember that your children have a right to love both of their parents unconditionally. Try to keep in perspective that even though the other parent is your ex or is about to be your ex, partner, wife, husband, etc., they are not your child's ex. They are your child's forever parent, just like you are. So please try to keep that in mind and in perspective when you are navigating your way through this and making decisions about how you approach your custody case. All right. Now we're going to turn to the don'ts. So I've been at this, like I said, a lot of years in family court and outside of family court, working with parents trying to resolve their custody-related issues in both of those forums. And we tried to educate at my mediation firm and my law firm clients on how to avoid the pitfalls that could hamper the outcome that they're hoping for in their custody situation. And there's maybe more than I could do in a short session, but I picked my top 5 don'ts for you tonight, okay? So number 1, this one comes up quite a bit. Don't talk to your children about adult issues, including court. And I don't know if I don't care if your child is 15, 16, 17, or just before their 18th birthday and you think, well, that's close enough to adult, or I confide a lot in my child and my child is mature and can understand this. Just don't do it. Don't talk about court. Don't talk about custody related issues. Don't talk about child support or your feelings about the other parent's new relationships and things like that. Just don't do it. It's not good. And if you end up in court and the judge presiding over your case finds out that you have been bringing the child into the legal arena by using them as a confidant, treating them as a friend, or trying to win them over to your side or speak out poorly against the other side, that will not bode well for you. It's bad for your child. It's bad for your custody case. All right, my second top 5 of the don'ts in handling your custody case. Do not bash your ex to anyone. I'm going to give you a limit of that in a minute, but to anyone, but most especially the children. So that's kind of a corollary to my first don't. But it's your job to make the other parent lovable to that child. It's your job to paint the parent and the other parent in the best light possible. And I'm not saying lie to your children if the other parent is drunk or is abusive or something like that, but do not bash them. Your issues as a former romantic partner with that person are not your children's issue with their parent. So don't bash your ex or soon-to-be ex to the children, and don't bash them anywhere else except where you have privacy and confidentiality. And I'm going to give you the limits for that. That is with your attorney, with your therapist, and with your priest. So you got 3 places that you could talk honestly about your feelings, about the strengths and weaknesses of your co-parent. But don't put it on social media. Don't talk about it at the school concert. Don't talk with the parents on the sports sidelines about it. Don't even talk to your very best friend, because things have a way of getting around, and your child doesn't need that. Your child is still in the same circle of people that they have always been in, and so if you are poisoning that well for them, you're doing great harm to your child. All right, my third don't say, don't do, don't write, or don't post anything that you wouldn't want a judge to see or hear. So for many people, that may mean take a break from social media. And that's probably not a bad thing. We actually advise our clients to do that if they can. And if they can't take a total break, keep your social media about recipes, vacations, puppies, happy things. Share funny memes that have nothing to do with relationships or parenting. But don't post about your court case, your breakup, or any of that, or new relationships, or your feelings about your ex's new relationship. Keep it out of the public forum. Also be very cautious about how you communicate by phone, in person, or by email or text with your ex, because those things have a way of showing up in court. So again, if you wouldn't want the judge to see it or hear it, don't write it. This is not the time to go on the attack on text or email. And what I'm going to tell you now is specific to New York. If you are already breaking up, and especially if you are headed to court because there's no agreeing or mediating to things, or you're already in court, assume in New York that the other party is recording all of their conversations with you, whether that's on the phone or it's in person. So I'm talking spoken conversations. And why I say that's specific to New York is because in New York, it is not a crime to secretly record a conversation as long as you are a part of it. So if you are standing next to your ex and you are having a conversation and that person has their phone on record in their pocket or in their jacket, and they're secretly recording you and you aren't aware of it, that is not a crime. It's allowed, and that can come into evidence in a courtroom in New York. So if you go off on a tirade and call them all sorts of horrible names or threaten them or something like that, and they catch you on a recording, that could have serious repercussions for your custody case. All right. My next don't. We're on number 4. Don't coach your children on what they should tell their attorney, what they should say to the judge in court, what they should tell their therapist about the custody situation. Just don't coach them. Let them have their own thoughts and opinions about the situation. Don't interrogate them after they've been spending time with the other parent and they come back for your parenting time. It's fine to say, I'm sure you had fun with mom, or how was your weekend with dad, and let the child talk freely, but you don't want to ask them who was there, did the other party drink, was there smoking involved, or don't interrogate the child about what went on during their time with the other parent with the eye that you're going to, find a gotcha in there that you can use against the other parent. And do not record the video record voice or video, audio or video of your children for the purpose of getting their reaction to having to separate from you, or their reaction upon being brought back from the other parent as evidence, right? You don't want to record them as evidence. Judges frown upon this. Children will, depending on their age and maturity, will potentially understand that that's what's happening. So that is really not appropriate. What I'm not talking about here is that if you notice an injury or a wound or something on a child and you want to take a photograph to document the child's condition, that's acceptable. But don't video the child when they're saying, but mommy, I don't want to go see daddy, he's not nice to me. Don't video those sorts of things for the purpose of, hopefully being able to present those in court, because in all likelihood the judge won't allow it and it will just reflect poorly on you. All right. My last don't, if you can avoid this, don't let a stranger in a black robe decide what's best for your children. And in order for that to happen, I want to encourage you to be reasonable, to be realistic about likely outcomes, and that means getting good advice from an attorney if you've got an attorney in your corner about what is likely to happen. Don't ask for the other parent to have zero contact if your attorney is saying, well, there's not a basis for this court to award that. So set your expectations at a realistic level and be prepared to compromise. I said earlier that if you've been in an intact household raising your children and you have access to them every minute you are home and free with them, or every minute you are available to go to their school events or sports events, and now some of your time is going to be the time the children are with the other parent, nobody loves that idea. Nobody loves it, but you have to be prepared to compromise. And really, that's going to be best. Resolving your case on terms you can accept through compromise is going to be better for you and better for your kids. So I hope you find these top 5 do's and top 5 don'ts helpful and informative. But I know that a lot of you had your own personalized questions, and we invited you to submit these questions in advance. So we have a number of questions, and we've got about 25 minutes left, it looks like. So I'm going to try to get through as many of those as I can, hopefully all of them. And if you are joining us but you didn't register or didn't think to submit a question earlier and you want to submit one now, you could submit one through a comment, and then it will be anonymous and private. Or if you are, okay with the question being tied to you or your Facebook profile name, you could put it right in the comments, and we'll try to get to any newly submitted questions as well. So the first question submitted to us states that my current custody order provides that if the children don't have school on a Monday on that parent's weekend parenting time, they get to keep the child or children through the Monday of no school. Then the question goes on, does that count for summertime too, since they don't have school? My ex says it's only for the school year, but my order does not specifically state only for the school year. So this is where it's hard for me to give specific advice. So reading it in a common sense way, I would say it applies only to the school year. But I could certainly see how that is vague and ambiguous by some people's reading of that. So It's important if you're entering into an agreement or a stipulation that you try to be as specific about all this stuff to avoid these future disputes about what does it mean, and parent A thinks it means one thing and parent B thinks it means another. So I suppose you would have to, know a little bit more about the context of how that provision came to be in the custody order. But I think it's open to interpretation, so I'm sorry I can't give you a solid answer on that one. You might also want to look at what does the language say about the parenting schedule in the summer when school is not in session. So if this language is in, the section of the agreement or the order about school year parenting time, and there's a different section about summertime, that would be clear evidence that this was meant to apply only during the school year. I don't know. That's the most help I can give. I hope that was helpful. Second question, how do we get court approval for a parenting plan? So again, I don't know how other states do it, but if you have reached a parenting plan and you have both got it in writing and it's signed by both of you and it's got the proper notarization, either or both of you can submit that to the court with a custody petition asking the court to, what we call, so order the parenting plan agreement. And then it becomes an order, and now it's enforceable as an order. So that's a pretty simple process in New York. When should we consider custody mediation? My ex and I agree on most things and do not necessarily want to go to court. So mediation should always be considered when you have not ironed out everything on your own, even though you made an earnest effort to do so. So if you've been talking, exchanging proposals, emailing back and forth, and you've got most things ironed out and agreed to, but you're just stuck on a few, it's a great time to bring in a mediator and see if the mediator can help you get unstuck and bring you over the finish line for a complete parenting and custody agreement that can then be approved by a court as a custody order. Some people start out with mediation right out of the gate. Maybe they don't know what needs to be in a custody agreement, and the mediator, if they're experienced in family law and custody mediations, can help them with that or give them ideas about parenting plan arrangements and ways other families have done things that maybe you haven't thought of when you've been discussing what would our parenting arrangement look like now that we're separating. So mediation is a great low-cost, low-intervention way to stay in control of your outcomes with the help of somebody who can help you get over the hurdles of things that you're not seeing eye to eye on. Next question is, how do I respond to a custody petition? So this is important, and this is general, not individualized legal advice, but if you have to be personally served a petition in New York, that means someone has to, mostly someone has to hand you the paperwork. There are other ways to be personally served, but that's the most common. You'll want to try to respond before the date that you are required to appear. So the papers that you've been served would typically have a date, time, and place for you to appear in court. If you're not able to do that, you usually are given time. In New York, it's typical to get 20 days after your first appearance to file a written answer to the petition. But when you appear in court, you can certainly enter a verbal answer to the petition where you can say, I admit to the facts in the petition and I consent to what the petitioner is asking, or you can say, I deny the facts in the petition and I am opposed to the relief the petitioner is asking. And in many instances, it might be wise to file a written answer and perhaps a cross petition where you put forth your own facts and your own arguments for what you think the proper outcome could be or should be in the best interest of your children. Next question is, can I ask for custody even if I've never met my child? My ex just informed me I have a 4-year-old son. Do I need a paternity judgment? How do I go about getting a court order for that? So short answer is yes. Paternity is a prerequisite, an order of paternity or an acknowledgement of paternity. So if you were aware of the pregnancy and the child's birth, and you acknowledged paternity and allowed your name to be put on the birth certificate, that's fairly common. That's enough. So if you've acknowledged paternity and you are named on the birth certificate, that's sufficient evidence of paternity. Otherwise, you would need to file a petition for paternity, and the court would order DNA testing cheek swab or spit saliva test of both the child and the what we call putative father, the petitioning father, or the father the mother is naming if the mother's trying to establish paternity. And then once paternity is established, you could certainly at that point petition for custody and access to your biological child. Next question, 6. Can I represent myself in a custody trial? Yes. Should you? No. That's all I got to say about that. There's a lot at stake. I can't imagine what would be more at stake than your kids. What would be more important to you? Money? No. Kids, right? Your kids are the most important thing to you. Get an attorney at trial. In every jurisdiction, as far as I know, in the United States, if you income qualify, you can have a court-appointed attorney represent you free or for reduced fee, so that you are not left in a situation where you don't have somebody to represent you over a matter as important as custody. Next question, how do I request a custody modification? My ex is planning to move away with my child. So first thing you need to do is look at your existing custody order and see if it says anything about relocation or change of the child's residence or school district, as you might have enough in your existing order to stop your ex from moving too far away with the child if that's addressed already in an existing order. If it's not, and you are challenging the move away with the child, then you would file a custody modification petition. Those are available on the New York State Court website, online. You can download a form, or every family court clerk's office would have fill-in-the-blanks forms for people who want to try it themselves. Of course, I recommend you engage an attorney and have assistance and representation on filing that modification and presenting your case in support of that modification petition. What documents do I need to file and help me with child custody? So you're here tonight getting some good information, so that's a great start. We'll be talking about some resources at the end of tonight's FAQ session, so stay with us and we'll put some links to some resources, one of which is our free guide that you can download for everything you need to know to sort of understand the basics of child custody, and it's in writing. So if you're not taking copious notes, the child custody guide, which is free to you, will help you understand some of the basics. You really need to, if this is your first time establishing a custody and visitation or parenting time order, you need to file a petition for custody. That's really it to get your matter going. Again, that form, petition for custody, is available on the New York State Court website and at every family court clerk's office in hard copy that you can fill in the blanks. But we do suggest that you consult with an attorney and get assistance in handling that case. Number 9, what will the judge ask me if I go to court for child custody? How do they determine what is in the best interest of the child? So typically, the judge doesn't have that many opportunities to ask you questions. So along the way at the appearances before you get to trial, there's usually at least 2, sometimes 3 or 4 appearances where preliminary things are being addressed by the court. The judge may ask certain things of the parties. This is more common when you are not yet represented by an attorney. So maybe in your first appearance you haven't had a chance to hire an attorney. The court may ask you some simple basic questions. But typically if you have an attorney, your attorney will be speaking for you. And so you shouldn't have to dialogue directly with the judge very often. The exception to that is if you go all the way to having your custody case put to trial in the judge's courtroom. Your attorney will ask you questions, the other attorney will ask you questions, your child's attorney will ask you questions or has the ability to ask questions of you, and the judge, while you're on the stand under oath, can ask you questions that are of interest to him or her. So that's really the one official time that a judge would be permitted to specifically question you while you're under oath. And I talked about how does the court determine what's in the best interest of a child. It's really very fact specific, and it's all in how a particular judge is viewing the information and the credibility of the witnesses and evidence that he or she is seeing and hearing in the courtroom. Who testifies at a child custody hearing? Will my child need to testify? What if the other parent is turning against me? Will custody automatically be granted to the other parent if the child says he wants to stay with her? That's a lot. Okay, let's break that up. Who testifies at a child custody hearing? Generally, at a minimum, both the parents are kind of anticipated to testify. You're not obligated to testify, but if it's your petition for custody, you bear the burden of proving it. So most commonly, at least, you need to testify, and you can bring in any other witnesses you think are relevant, except for the children. You can bring in family members, neighbors, school teachers, counselors, doctors, social workers, whatever. Anybody you think has relevant information to the best interests of your child. The child doesn't officially testify in New York. There's an opportunity for the children, at the request of their attorney, to have a private audience with the judge. It's called a Lincoln hearing. So the children aren't officially put on the stand under oath and interrogated by the lawyers or anything, but the judge and the child's attorney and the child get to have a dialogue in private, and that's called a Lincoln hearing. If the other parent's turning against me, will custody automatically be granted to the other parent if the child says he wants to stay with her? No. In New York, children never have the say in the final outcome of their custody. I know in some states that once a child reaches a certain age, sometimes states it's 14, sometimes it's 16, they can determine their own custody outcome, or their preference will control. In New York, the child's preference never controls. It's never the deciding or the sole factor. The child's preference is given weight depending on the age and maturity and insight of that child in the position that they take. So in New York, their position is advocated through their attorney. And if a child is, the older the child is and the more mature the child's position is, the more weight the court will grant that child's position, but it's not determinative on its own. But you can imagine if your child's 17 and a half and they have a position on the outcome of the case, a court, as long as that position isn't harmful or unreasonable, the court's probably going to give very, very, very heavy weight to the child's decision. If your child is 7 or 8 or 9, probably less weight to the child's stated position. Who gets physical custody and how is this decided? So as I mentioned earlier, we now talk about how is parenting time shared, and that's really, pull out a calendar and map out when the child's going to be in mom's house versus dad's house, or if it's 2 dads and 2 moms, when the child in mom 1 house versus mom 2, or dad 1 versus dad 2. So we talk about the parenting time schedule being divided between the parties in some fashion. The only time the designation of primary custodian for physical custody matters is if the parents live in 2 different school districts. The parent in whose home the child spends the majority of the time is the residential parent for free public education. So if that doesn't make sense, let me explain. In my area, let's just say one child's in the Plattsburgh City School, one parent's in the Plattsburgh City School District and the other is in Beekmantown School District. If the child spends more time at the home of the parent who lives in the Plattsburgh City School, that's where they're entitled to go to public school, and they would not be permitted to go to Beekmantown because they're not a resident there, if that makes sense. Okay, moving on. If I have legal custody of my child, does that mean I'm the sole maker of decision concerning my child's best interest? That would be true if you have sole legal custody. If you have joint legal custody, remember you have to reach agreement with the other parent. You have to notify, confer, discuss, and reach agreement. How can I keep my information confidential from my ex? Is there a way I can stop him from finding out where I reside? Yes. In New York State, if you are the victim of domestic violence, or you've been threatened, or there's an order of protection in effect, you can fill out a form with the family court clerk's office that would allow you to keep your information, your residential information, your phone information, etc., confidential and not disclosed to the other party. and all papers to be served on you would either be put through the court clerk's office or to your attorney, so that your address and contact information would be confidential. Next question is, what does the lawyer for the child do? Is it normal to have one, and is everything that the child says kept confidential? This is a great question. So in New York, we have what's called attorneys for the children, or an attorney for the child, an AFC. In other states, there's a law guardian or a guardian ad litem. In New York, I think our role is defined a little differently in some other states. So the attorney for the child is like any other attorney. They're to advocate zealously for the position and wishes of their client, of their child client in this case. So the attorney for the child is supposed to advocate for the child's wishes, unless advocating for the child's wishes would be imminently harmful to the child. So let's just say the child wants to live with a parent who is actively selling drugs from their home. And for whatever reason, the child says, I prefer that parent, I want to live there. Maybe because there's no rules, maybe because their boyfriend or girlfriend can sleep overnight there and that parent doesn't object, whatever. But if in that situation, if the court felt that was, or the attorney for that child felt it was imminently harmful, and probably they would think that, they would have the opportunity to advocate something opposite or different than what their client, the child, wants them to advocate. Everything the child says is kept confidential unless the attorney in their discretion feels it is necessary to disclose that information to advance the child's position, or they have the express permission of their child client if the child is old enough to give permission. Otherwise, the things the child discloses about a parent or what goes on in the parent's households, etc., is generally kept confidential. And if the child divulges information that would be unflattering about one or both parents, typically that attorney wouldn't reveal that and put the child in a bad position if the child was to find out that they tattled on their parents, so to speak. What's the role of a caseworker, and is this applicable only for children that are seeing a psychologist? So I'm not sure what the context of this question is meant to ask, but I'm going to go out on a limb. So in New York, we use the term caseworker for a child protective services caseworker working with the family. Not every custody case, in fact, the minority of custody cases have involvement of child protective services. So it's far more common to have no caseworker at all. If there is a caseworker, and the Department of Social Services has petitioned on behalf of the child alleging that one or both of the parents is abusive or neglectful, then the caseworker has an important role in interfacing with that family throughout that court proceeding. That may mean offering services to one or both of the parents, checking in with the child, and setting up services for the child, etc. Yeah, okay. Next question is, can I file for custody in New York of my kid who has only lived here 4 months, or do they have to be in the state for a number of years? So that's another great question. So in New York, if there's no existing order of custody, so this is the first time anybody's gone to court over custody of this child, the proper state to file that custody petition is the state where the child has lived consecutively for the most recent 6 months leading up to the filing of the petition. So in this question, the child has only been in New York, living in New York for 4 months. So that's a signal that maybe New York is not the proper state unless the child is only 4 months old. Like if the child was just born and hasn't been on the earth for 6 months yet, then New York would be a proper state in that scenario. What if that child has never been anywhere for more than 6 months? Well, you might have a hook to get into New York. So for kids who have been moved around a bit, perhaps military parents, perhaps parents whose job moves them around a lot or something, you might have to make a case of where has the child had the strongest, most consistent presence. What state or jurisdiction would that be? The next question is child support related. I'll quickly see if I can address it. If my ex is behind on child support, can I refuse that he see my children, or is there another way that his visitation rights can be refused? That's a hard no. Custody and support are generally not interrelated in that way, so you can't deny a parent access, especially if you have a court visitation order or custody order, simply because they're behind on the child support. Your remedy there is to pursue enforcement and collection of your child support order, but you cannot stop their visitation rights on your own. Otherwise, you would face a potential violation of your custody visitation order. Can either parent file for custody after divorce proceedings have begun? So again, at the risk of sounding a little hyper-technical, in New York, once you've started a divorce, if you have children, the divorce court, which is the Supreme Court of the state of New York, that's the court that handles divorce matters, they would have authority and indeed the obligation to address your custody issues as part of your overall divorce proceeding. In New York, you can, if you have not started a divorce action or you have never been married, you can file for custody in family court. But once you start a divorce case, you're prohibited from then filing a family court custody matter separately. So your divorce judge would handle it. You wouldn't have a need to go to family court. And in fact, you would be prevented from doing that unless the Supreme Court judge gave you permission to have your custody issue addressed in family court. What about grandparent rights? Do they apply in a child custody case? That's another topic that could take, we have done actually a whole Facebook Live on it. So I'm going to ask my support team behind the scenes to put a link in the comments to our free guide to grandparent rights in New York State. And that will tell you everything you know and then some about the question that was asked submitted ahead of time. So if that was your question, look for the link to download the guide, please. What is visitation mediation, and can it be used to change a visitation order? So yeah, you can mediate all elements of a custody arrangement. You can mediate whether or not you have joint legal or sole legal custody. You can mediate the parenting time or visitation. You can mediate any element of issues relating to your parenting, including child support related issues. And can they be used to change a visitation order? Yes, they absolutely can. So the procedure is mediate, get your agreement, get it in writing, put your signatures on it, and have the proper notarization, and then you can submit it to the court to request the court modify your custody visitation order, the prior custody visitation order. All right. Final pre-submitted question is, are there ways to settle your child custody case without going to court if your co-parent refuses to go to mediation? Unfortunately, that's very common. So mediation in New York is, in our court systems anyway, it's voluntary. So we don't have mandated court referrals to mediation before the court will hear your trial. Some states do, and if you're in the state, you're going to be required to give mediation a try, and I think that that's actually probably a good thing in most situations. But we can't force parties in New York to go to mediation because it's voluntary. So your options are hammer it out on your own, or hire attorneys who are problem solvers who will help through unofficial, you're not sitting down with a mediator, but just negotiating back and forth with the advice and guidance and support of a level-headed problem-solving attorney who will help you try to figure this out without the expense and the uncertainty and the stress of putting yourself and your kids through a litigated court situation. All right, that was all of the pre-submitted questions. Let me just check the comments. I don't think that there were any new ones submitted. And we are right at 8:01, so how about that? So all right, I'm going to wrap up with a couple of things, and I want to give you some bonus stuff here. So already in the comments, you have the access to the free downloadable child custody guide. We have the grandparents' rights guide, and let's see, a link if you would like to get a one-on-one individual consultation with our team at Whitson Law Firm about your custody situation, that's the point at which we can give you individualized guidance, advice, and talk strategy with you. So what I've done tonight is very generic, but if you want to get deep into your particular situation, please check the link and set yourself up to book a consultation for a custody consultation with us. Also, download our Divorce Like a Pro book. Yes, that's divorce focused, but it also addresses custody related issues, and it goes over all of your various options, from sitting down at the kitchen table and working out your differences and coming to agreement on these issues, to mediation, explains collaborative law and how that's different from mediation, and then what to expect if your matter ends up in the courthouse. So there's great information in there for you when considering your options and knowing what to expect in those various modalities. And then finally, I would like to announce and have you look ahead. If divorce is part of your situation or in your near future, we are having a webinar which is much more structured and formal and chock full of great information. It's called the 10 Critical Mistakes to Avoid Before You File for Divorce. So if you've been thinking about that's where you need to go next, is to start a divorce process underway, get that underway, then join us. The webinar will be hosted on Facebook, and it's going to be held March 27th at noon, March 27, 2003 at noon, for approximately an hour. You'll get some great written materials and some slides and pictures of printouts of screenshots and slides that you can take with you, the opportunity to ask questions and more. So look for that. You can send us a private Facebook message with your email address to say webinar and give us your email address, and we will email you a link to the webinar when everything is set up and ready for registration on Facebook. But you can find it there. We'll be advertising the webinar on all of our social media outlets. You can find us as Mediated Online Solutions on Facebook and Instagram and Twitter and LinkedIn, and as Whitson Law Firm on Instagram, Facebook, Twitter, and LinkedIn. So thank you everybody for coming tonight. Again, I'm Debra Whitson, owner of Whitson Law Firm in Elizabethtown and Mediated Online Solutions in Keene, New York. And it's been great spending time with you. I appreciate all of the thoughtful questions that you had submitted in advance. And drop us a note. Let us know if this was helpful for you. And if you thought of a question that you haven't submitted, or you're watching this after it's live and there's a question that you would like to submit, feel free to do so in using Facebook Messenger, and one of our legal team will get back to you with an answer to your question. In the meantime, stay well, take care of yourself, take care of your kids, and we'll see you on Facebook Live again soon. Good night now.